Welcome friends to the second video on this series, Indirect Touch Case Laws. The idea behind these videos are just to share some interesting case laws that I come across, and I feel it's a little easier to listen to an audio than to read it in a complete article format, both for the author and for the reader. So that's the idea behind sharing some few case laws in this series of case laws. So here in today's video, I've just picked up some three recent case laws that I came across that I thought I can share it with you guys. So the first case law here is Silchar Technologies Limited, which is a Gujarat advance ruling. The issue is on GST classification. And the second one is NPay Transformer Components India Private Limited, which again is a Gujarat ruling. And there are two issues here. One is on import of goods valuation, and the second is on RCM on reimbursement. The third issue or the third case is Pratiksha Bharat Gas Gramin Vitrak, which is a Madras High Court case, and the issue deals with cancellation of GST registration. So these are the three cases that I have picked up for discussion in this video. So the Silchar Technologies Limited is a first case, and here what has happened is the Adani Group has three solar projects happening at three different places in India, and for this a contract has been given to Silchar Technologies for supply of transformers, which is aluminum foil type winding inverter duty transformer. So this is a part that gets classified under 8504. Now the question before the advanced ruling authority is whether this will be eligible for a GST rate of 5%. So this is a solar power project, and here supply to this has some special rates and valuation under GST. So I have just given some excerpts from the notification. So if you can see, 1 bar 2017 is the rate notification for goods, and 11 bar 2017 is the rate notification for services. So these has been amended on 31st December 18 by two notifications, which are 24 bar 2018 and 27 bar 2018 respectively. So this is with effect from 1st January 2019. These amendments have been made into these notifications. So what happened in this amendment is what has been highlighted in green here. So in 1 bar 2017, that is in the goods notification, an explanation was inserted which said that if the goods specified in this entry are supplied by a supplier along with supplies of other goods and services, one of which being a taxable service specified in an entry at serial number 38 of the table mentioned in 11 bar 2017, then the value of supply of goods for the purpose of this entry will be a deemed valuation. So basically what the explanation is inserted is, as I said, 1 bar 2017 is a rate notification for goods. So however, if you are supplying 8504 part which is going to be used for say a biogas plant or solar based power plant or solar based lamps or lanterns and wind based projects. So if these kind of projects, if any such part is being supplied, and along with supply of such goods there is also a taxable service that is being supplied, right? So then the law says in that case the valuation has to be a deemed valuation, of which 70% should be goods and 30% should be services. So for a similar amendment was also made in 11 bar 2017, which is the service notification, where again an explanation was, a new entry was inserted where it said that services by way of construction or engineering or installation or other technical services provided in relation to setting up of the following. So just what we discussed, the same which is there in 1 bar 2017 amendment, which is a biogas plant, solar power based devices, solar power generating system, etc. So in this case, if you provide a service of say construction or engineering or installation or other technical services in connection to the supply of the parts which is coming under 8504 and those chapters, then a deemed valuation will get applicable. An explanation was also inserted in serial number 38, which says that 70% is goods, 30% is services. However, in this case, the facts of the case are little interesting, where the fact says that the applicant has two POs, two purchase orders, one specifically for the purchase of goods, that is the supply of transformers, and 2 another purchase order specifically for services. But here it is not service of erection or commissioning of the plant, but it is more of a supervision. That is, if erection testing and commissioning is done, the Silchar Technologies is going to supervise such erection testing and commission. So since there were two purchase orders, the appellant wants to understand from the authority whether can they go for 5% on the full value, which is the transformer value for goods, and 18 percentage for the value of services, without adopting this deemed valuation of 70% and 30%. So this is the question before the authority, whether they can go for such arrangement. So here the authorities have analyzed, first of all, what is a solar power generating system, because the word as such has not been defined in the law, and they have gone to the jurisprudence of central excise regime to understand what is solar power generating system, and they have concluded that such transformers, inverted duty transformer, are an essential component of the solar power generating system, and hence it will qualify for the 5% entry in 1 bar 2017 that they have accepted and confirmed. However, when they go to analyze whether is it a taxable service is involved in relation to the supply of this service of transformers, should they go for this deemed valuation, the assessee has said that they are not under any compulsion to supply transformer and services together. They are two different purchase orders, and they can go for the valuation in respect to transformer, that is goods separately for 5% and service separately for 18%. However, one thing that has been crucial here is the advanced ruling authorities has asked for the contract or agreement, which was not available and not provided at that point of time. So the advanced ruling authorities had only the POs to rely, and another important thing that was noted in the PO is the POs refer to another document called technical specification, which is a single document. So this technical specification is a single document which covers a detailed scope of the service, whereas there are two POs separately for goods and services. So on the goods PO, what is covered is mainly the design and manufacturing and still packing and delivering it to the site of the customer, and the service PO has the supervision of erection testing commission. So this all this is detailed in the technical specification of how for how the supply has to be delivered and what are the requirements. So the advanced ruling authority has said that since there is only one technical specification document, it is common for both, and this PO has been just because there are two separate POs, it cannot be said that the rate deemed valuation should not be adopted. So since there is only one specific document, it is, and there was no agreement also provided separately for these two, the deemed valuation of 70% and 30% is very much applicable in this case, because the service is inextricably connected to the supply of transformers is what has been this ruling. So the ruling has said that the applicant has find out a way not to pay GST in terms of the explanation inserted to serial number 234 of the notification 1 bar 2017. Therefore, the artificial bifurcation of the PO into supply of goods and services is only to bypass this provision, and the ruling is of the view that the contract is single for both supply of goods and services. And although, as we mentioned, the contract is not for erection commissioning etc., it is only for supervision, still the ruling has said that this would qualify as other technical services under entry 38 of the service notification, and hence since this other technical service is provided with the supply of goods, the deemed valuation will be very much applicable, and the effective rate of this will work out to 8.9 percentage, being 70% of 5% and 30% of 18 percentage, and this has to be applicable in the current scenario is what is held in Silchar Technologies. Now go on to our second case, which is NPay Transformer Components India Private Limited. So here the facts of the case, as we can see here, that the appellant is importing some goods from its group company in Turkey. And here the Turkey group company says that the payment has to be made within 120 days. If it is not made within 120 days, then the appellant Indian company has to pay interest to its group company. So here the question comes whether on the interest payment that is made by the Indian company, should there be a tax liability on a reverse charge basis that has to be discharged in India. So another point to note here is it is only import of goods, friends. That is, a goods has been imported from Turkey to India, and delay of 120 days, more than 120 days, if there is delay in payment of consideration for this goods, should I pay RCM on the interest for this delayed payment? And there is a second query also in this ruling, where the Turkey group company has taken a has given a corporate guarantee for the credit facility taken by the Indian company. And in this process, the Turkey company has paid stamp tax in Turkey, which is as per the rules of the that country. And for this, they have raised a reimbursement invoice on the Indian company. So the query is, on such reimbursement invoices, should there be a reverse charge mechanism on the Indian company? So the analysis of this NPay case, the ruling has said that the foreign buyer who is outside India and the Turkey has tolerated an act, and it is a service. So as we all know, Schedule 2 says that agreeing to an obligation to refrain from doing an act or to tolerate an act or situation is a service. So Schedule 2 clarifies that. So the ruling has said that the foreign buyer has tolerated this delay, and hence it is a service that has been provided. However, since the payment of interest is connected to the goods imported by them and is with regard to the late payment of the value of goods imported by them from the foreign buyer, we find it absolutely necessary to refer to section 15 of the CGST Act. And we all know section 15 subsection 2 has this component which says interest or late fee for delayed payment of consideration has to be included in the value of supply. So considering Schedule 2 and Section 15, the authority has held that for the import of goods which is come from Turkey, this interest on delayed payment of consideration should form part of the value of the supply, and the tax has to be paid on a reverse charge basis. However, on what rate it has to be paid, also the ruling has gone and clarified, saying this, since it is connected to the goods that is being imported, the rate of tax should also be same as the rate which is charged on the good. Although the ruling has held that RCM is payable on such interest on delayed payment of consideration for import of goods, one thing that can be noted is that on import of goods, that the levy is coming from the IGST Act, and in the IGST Act, the first proviso to Section 5 says that the levy is been delegated to the Customs Act on the value determined under the said Act. So the valuation as per customs provision also could have been analyzed in the said ruling, which has not been analyzed, which is one observation that we need to have when we look at this case for the first question. Now for the second question, whether liability to pay GST on the reimbursement of stamp duty. So here what has happened is the stamp duty has been paid by the Turkey company outside India, and they have raised a reimbursement invoice to the company in India. However, on going through the ruling, we understand that there has not been sufficient documentation to prove that there has been a pure agent relationship in this situation. A pure agent is someone who is not going to own any title on what he has paid or procured. However, since the documentation were in a foreign language and there was no proper evidence or an agreement or contract to show authorization that the Turkey company can pay on its behalf, so for various procedural reasons, the conclusion could not have been obtained. However, since the Rule 33, that is the pure agent per se, could not be established or satisfied by the applicant, the ruling has held that this is not on a pure agent capacity, and hence, since it is a reimbursement and consideration definition includes any payment made or to be made, and this also is in relation to the supply of goods, and hence reverse charge mechanism is applicable for such reimbursement invoice, as section 15 includes any does not exclude reimbursement. So they have gone to give a ruling which says such reimbursements is going to also have a RCM impact. Now moving on to the third case, Pratiksha Bharat Gas Gramin Vitrak. So in the facts of the case, the show cause notice has been issued to the applicant on July 2019 asking to show cause why the return has not been filed for a continuous period of 6 months. And after which on 16 September 2019 the registration was cancelled by the authorities, based on which the applicant has filed revocation of such cancellation. So there has been two applications that the applicant has filed, and the first application was rejected by an order on 24th July 2020, and referring to that there is non-compliance to the notice issued by the AO. And the second application for revocation was also rejected on 12th September 2020, referring that there are outstanding interest on belated payment of tax dues and ITC has been wrongfully claimed in certain cases. So the appellant, so the applicant has gone for an appeal, whereby based on the second rejection order, he has gone for an appeal, and the appellate authority has issued a deficiency memo asking to reverse the ITCs that was availed wrongly during the previous period. And hence this deficiency memo and the rejection order has been taken on appeal or on a writ before the Madras High Court. So the Madras High Court has said that the contention of the respondent, that is the department, that a revival of a registration is conditional upon the petitioner satisfying the tax dues and substantiating its claim of ITC is misconceived. An assessment would have to be made by the authority in terms of section 73 or other applicable provisions for after following the procedures set out therein, and it is only in that course thereof the officer may consider and decide the questions of leviability of tax and claim of ITC. So therefore, in the guise of admitting or rejecting a revocation application, the authorities should not do a assessment procedure, is what has been mentioned in the ruling produced by Madras High Court. Thus, to state that the registration will not be revived since the petitioner has incorrectly availed ITC would be putting the cart before the horse. The petitioner has filed all the GST returns for FY 17-18 till September 2020, including the annual returns, and these being the only conditions that are to be satisfied for the petitioner for grant of revocation of registration, I am of the view that cancellation of registration in this case is incorrect and improper. So let the respondents first pass an order reviving the registration of the petitioner. Forthwith, the respondent is at liberty to take up matters of assessment thereafter in accordance with the law. So this is again an important ruling which says that the process of revocation of registration and the process of assessment should not be clubbed together, and it has their own separate mechanisms under the law. So these were the three cases that I thought I can share with you people in this video. So I hope it would have been useful to you to go through these videos and understand little on the case laws. So let us meet in the next video where I'll try to come up with more interesting case laws to share with you all. So until then, feel free to share your feedback. If you like the video, please give a thumbs up, share and subscribe. So let's meet in the next video on indirect tax case laws. Thank you.